to be what I said on the record? Because we can get the transcript. So if I'm amending the order
Your Honor, that's true.
what I said on the record,
but you did, an order was filed on the file.
Mr. Gregory, do not ever interrupt me.
Welcome back to the courtroom breakdown where real justice gets real dramatic. Today's case dives deep into a probation showdown involving Brittany Lingoski, a defendant who says she did everything the court ordered. But Judge isn't buying it just yet. Because one key condition is missing: mental health treatment. Now here's where it gets heated. The court's trying to verify if she's still in therapy, and it quickly turns into a back and forth of who said what between the attorneys, probation officer, and even the judge himself. This isn't just a paperwork problem, it's a probation deal breaker. If she can't prove she's still in mental health treatment, the judge won't sign off on discharging her probation, and this whole thing could blow up in her face. Stay tuned, because there's a twist involving a missing document, a mistaken identity, and one very frustrated judge who's not in the mood for games. Let's dive in.
Good morning, Ms. Langowski. I'm going to send you to a breakout. I'm going to send you to the breakout room. Wait for the lawyers to come in to talk with you. Please join breakout room number 9. I'm ready on Jackson. All this time, does Ms. Jackson have on a white t-shirt? I'm gonna put Ms. Jackson back. Oh, this is Ms. Langowski. I said Jackson. That's Ms. Langowski. I'm gonna put Ms. Langowski back in the breakout room.
Okay.
And then she's gonna change her shirt.
Did the judge just tell her to change her shirt? Yep. Welcome to Zoom court, where even wardrobe becomes court-ordered. This moment might seem odd, but maintaining courtroom decorum, even virtually, is still a thing. Judges expect participants to show respect, and yes, that includes how you're dressed. It sets the tone and shows you're taking the process seriously. In person or online, court isn't casual. And a minor outfit comment like this often signals that the judge is already on edge. Which, spoiler alert, becomes very clear later.
I have to change my shirt?
I'm ready on Jackson.
Yes.
Ms. Jackson, start your video. I need her order, because this isn't, hold on. Oh, here it is. She has paid her fines, costs, and fees. She has completed her anger management. It doesn't say anything about her mental health treatment. Can you call Miss Bumpus and ask her if she has any verification of the mental health treatment? Mr. Gregory, what's going on with the mental health treatment?
Your Honor, the report that I got indicated that she was...
This is where the confusion kicks in. Mr. Gregory insists all probation conditions were met, but the judge's copy doesn't mention mental health treatment being completed. That's a huge red flag. In legal terms, this is a misalignment between the filed order and the court's expectation, and in probation cases, that can derail everything. It's not just about checking boxes. If mental health was a condition of probation and she can't prove completion, the court can legally refuse to discharge her. Paper trails matter in the justice system, and right now, this one's looking sloppy.
Completed with her. She had no remaining conditions.
That's what it said, but the completed conditions doesn't say anything about mental health treatment. Completed condition says she's paid her balance, she's done her anger management, and doesn't say anything about mental health treatment. Her order indicated that she was supposed to continue with her mental health treatment. So has she continued with mental health treatment?
Your Honor, we may have to go back into a breakout room.
Am I allowed to speak?
You may.
I am in therapy. I still do therapy. That was one of the things why I was in therapy when I got sent the thing that I was supposed to do. But yes, I am still in therapy.
Lingoski finally chimes in, and she's calm, respectful, and clear. Yes, she's in therapy, and no, she didn't know she had to provide proof. That matters. Courts actually expect defendants to proactively submit documentation, but her honesty here may actually help her. She's not defiant, she's cooperative, and for many judges, that counts. Still, probation isn't based on good intentions, it's based on verifiable compliance. And that's where she's stuck. What do you think? Should the court give her the benefit of the doubt or hold the line?
And did you provide proof of the therapy to your probation officer?
No, I didn't know I was supposed to. I spoke with her a few days ago and she said everything was in, so.
Okay, well, let's see. I don't know why she would say that without giving me an update on the therapy. Okay, Mr. Flanagan, do we have an update on Lingowski?
Oh, yes, Your Honor. I sent you a chat.
Oh, okay, thank you. It's not true. It's not true. I'm looking at the order. I'm looking at the order. Who said that? I'm looking.
Ms. Bumpus.
Who?
Ms. Bumpus.
So you telling me that Brittany Lingowski did not get ordered to pay $810, and then her order does not say, shall not violate any laws, must report monthly, must notify probation officer of change of address and work status, shall not use or possess any illegal substances, shall not use or possess any marijuana without a valid medical marijuana card, shall not use or possess any opiates without a valid prescription and letter of explanation from the doctor, shall not drive without a valid driver's license, 4 weeks of anger management, must continue with mental health treatment, maintain no contact with complaining witness Crystal Harris. You're saying that's not her order?
Everything is listed except for the continue with mental health treatment.
I have this order right here in front of me.
Here's where the judge takes control, reading every single condition of her sentence verbatim. And when a judge starts reading from the record like this, that means they're losing patience, and they're preparing to make it court official. From fines and anger management to no illegal substances and no driving without a license, the list is long. And right in the middle, must continue with mental health treatment. There it is. The order is clear. So why does the defense claim otherwise? That's the contradiction that just escalated this hearing from routine to risky.
So what are you saying? It's two
Oh,
orders?
I'm looking at the order of delayed sentence that's in the file.
Okay, Jesus. All right. I want proof of her mental health treatment before I discharge her from probation. I just can't imagine why that wasn't on there.
Your Honor, respectfully, Ms. Lingowski has followed the court orders and has continued.
Mr. Gregory, I want proof of her mental health treatment before I discharge her from probation. She has indicated that she has been in treatment even before she was sentenced. Getting proof of that treatment is immediate and easy.
I understand, Your Honor.
I'm not discharging her from probation.
This is the turning point. The judge draws a line in the sand. No proof, no discharge. He's not being petty, he's protecting the legal process. The justice system relies on documentation. If one piece is missing, even if the defendant is actually in therapy, the court has no legal basis to close the case. And then, judge drops the bomb. I'm not discharging her from probation until I get that proof. No argument, no debate, just a hard stop. It's courtroom accountability in real time.
Until I get proof that she is in the mental health treatment. Anything further? Because I'm gonna give her a week to get us that proof.
I just want the record to reflect that
The
she
record
did
reflects it.
follow
The record reflects
the court
Mr.
orders.
Gregory, I'm not
I
gonna
understand,
argue.
Your Honor, but I would listen, Your
Mr.
Honor. I
Gregory.
would like to make this on
Mr.
the record.
Gregory, Mr. Gregory. I want proof of her mental health treatment. So if that is going to reflect, I'm amending the order to be what I said on the record, because we can get the transcript. So if I'm
Your Honor,
amending the order
Your
to
Honor, that's
reflect
true.
what I
So we
said
can get
on the
transcript,
record,
but you did, an order was filed on the
Mr.
file.
Gregory, do not ever interrupt me. If it's an issue of me amending the order to reflect what I said on the record, then that's what I'm doing. I'm amending the order to reflect what I said on the record, which is continue in mental health treatment. And since Ms. Langowski has said today that she has continued in the mental health treatment, then it's no issue. I don't even know why we're discussing it. So she's going to get the proof that she has continued in the mental health treatment, and then I'm going to discharge her from probation.
Understood, Your Honor, but everything that is an amendment on the record should be discussed.
This is going south. It's really going south at this moment. It's really going south.
When the judge says, "Do not ever interrupt me," that's courtroom DEFCON 1. This is no longer about therapy, it's about respect. Mr. Gregory, her attorney, tried to clarify the amendment process, but cut off the judge in the middle of a ruling. And that's a major misstep. Judges run the courtroom, period. Interrupting them while they're issuing an order is like yelling at a referee during a ruling. It's not going to go your way. If anything, this exchange made it less likely the judge would extend any leniency.
I'm going to say this for the last time. That's my order. That's my order. I'm going to say that for the last time. That's my order. Ms. Langowski, how long is it going to take you to get proof of the mental health treatment?
I can drive up there right now and get the paper. I go down the street to therapy. So do I just upload it somewhere or send it somewhere?
Yes, you're going to send it to, you could send it to Ms. Bumpus, or you could send it to Mr. Flanagan.
And then I have
Your
to
Honor,
come
if you
back.
can get that paperwork in today, would it be able to be this?
Absolutely. Do you need Mr. Flanagan's email address? They may not be able to give it to you today. But if they give it to you today, you can send it today. And if not,
they gave me one. My lawyer was Scott Weinberg, but he's not my lawyer anymore. So I'm assuming he didn't upload it, but they gave me a paper back when I was supposed to do all this, and I thought it was all uploaded. But they'll literally give me a sheet of paper today saying that I'm in treatment.
This moment? It might have saved her case. Langowski takes control, calmly explains she can walk to her therapy provider and get the paperwork today. She even asks where to send it. That initiative is key, because now the judge has a clear, immediate path to verify compliance. It shows responsibility, and more importantly, it gives the court what it needs to close the loop. Let this be a reminder. If you're in court and your freedom depends on paperwork, go get the paperwork.
okay, well then, let me give you the email address to send it to.
Okay. Okay, I'm ready.
At 36th districtcourt.org. That's the numbers, 36.
Okay.
If you email him that today, I will dismiss the matter with prejudice. I will remove the conviction from your record, and I will close the case with improvement.
Okay, thank you.
If you cannot get it to him today, call the courtroom and let them know when they say they can get it to you, okay? If for some reason they can't. So do you need the courtroom phone number?
Yeah, I was supposed to call Ms. Bumpus after court today too. So I can send it to both just to make sure it gets there.
Okay, that sounds great.
Okay. And what's the court number?
965-2295.
Okay. Thank you.
All right, you're welcome. Have a great day. Stay safe.
You too.
Thank you. Mr. Flanagan, send me that order because I'm trying to figure out why you have a different order than I do.
So let's recap. This wasn't just a case of missing documents. It was a real-time lesson in courtroom precision, defendant accountability, and how quickly things can go south over one unchecked box. Judge needed proof of mental health treatment, and until that hits the inbox, probation stays active. But Lingoski may have turned things around by stepping up at the end. What do you think? Was the judge too strict, or just doing his job? Let us know in the comments. And if you found this case as shocking as we did, make sure to hit that like button, share your thoughts, and subscribe for more jaw-dropping courtroom breakdowns every week.